It is 8:47 in the morning, Denver, Colorado, the USCIS field office on Stout Street. The waiting room smells like disinfectant and quiet desperation. She has been waiting for this appointment for 11 months. 11 months of saving documents, 11 months of organizing folders, 11 months of telling her children, soon, we will have our answer soon. Her name is called. She stands, she smooths her jacket, she walks through that door, confident, prepared, ready. Door closing, silence, a single notification ping, a phone screen, an email, subject line, application denied, public charge grounds. 22 minutes later, she walks back out. No green card, no path forward, no explanation she was ever warned about. And the reason they gave her? A credit score. Her face. Not crying yet, just still. The kind of still that comes before everything falls apart. If you are on a visa, applying for a green card, or building a life in this country, at what you are about to hear could be the difference between staying in America and being told to leave it. Starting in 2026, your credit score, your debt history, your financial decisions are now part of your immigration record, and most immigrants have no idea. That silence, that not knowing, is exactly what this new policy is counting on. Stay with me, because in the next few minutes, I'm going to show you exactly what changed, exactly what they are looking at, and exactly how to protect yourself and before your next immigration appointment. Here's the mistake that thousands of immigrants are making right now. They believe that if they work hard, pay their bills, stay out of trouble, they are safe, and they are right, mostly. But here is what nobody told them. Immigration officers are no longer just asking, are you law-abiding? They are now asking, are you financially self-sufficient? And that question, that one shift, changes everything. Because under the 2026 expansion of the public charge rule, combined with updated Form I-944 financial assessment protocols, immigration officers can now examine your credit score, your credit history, your debt-to-income ratio, whether you have used certain government programs, whether you have financial assets or financial liabilities. And here is the mistake most people make. They think their credit history is private. They think their bank account is their own business. They think being broke is not a crime, so it cannot hurt their case. But under the new framework, being financially unprepared is being treated like a red flag, not a crime, but a reason to deny. And denial, with no warning, no second chance, no appeal window, is what is happening to families right now. She did not break the law, she just did not know the rules had changed. You will not make that same mistake, not after today. You have heard it before. Maybe you even said it yourself. Immigration is about documents, not credit scores. That's for banks. That belief is now dangerous. Here is the truth. The 2026 Public Charge Assessment Guidelines now explicitly include credit history as a factor in determining financial stability. A low score, or no score at all, and can raise what officers call a negative factor in your file. Why do people fall for this? Because for years, it was true. Credit scores had nothing to do with green cards. That changed, and nobody sent a memo. Here is your exact move. Check your credit score today, not tomorrow. Today. Use annualcreditreport.com, the only federally authorized free report site. Get all 3 reports: Experian, TransUnion, Equifax. If your score is below 700, start building it now before your next immigration milestone. A credit score is no longer just financial. It is now part of your immigration identity. This one is causing panic, and the panic is leading people to make it worse. Immigrants are dropping health insurance, refusing emergency care, telling sick children, we cannot go to the doctor right now, because they are terrified that using any benefit means the end of their green card dream. Here is the truth. Not all public benefits trigger public charge. The law is specific, very specific, and most people are catastrophizing based on incomplete information. Why do people fall for this? Because the language in immigration forms is designed for lawyers, not for families, and fear fills the gaps that clarity leaves empty. Here is your exact move. Know the difference. Programs that do count against you under current policy: supplemental security income, cash assistance through TANF, long-term institutionalized care paid by Medicaid, programs that generally do not count, emergency Medicaid, CHIP, the Children's Health Insurance Program, Medicaid for pregnancy, food banks and community assistance, school nutrition programs. Write that list down. Share it with your family. Do not guess, know, and if you are unsure about something specific, speak to an accredited immigration representative before your next appointment. Silence is not safety, knowledge is. This trap does not just hurt your case, it can end it permanently. Some immigrants walk into adjustment of status interviews unprepared for financial questions, assuming those questions are optional or off limits or easily deflected. They are not. Here is the truth. Under updated Form Y-944, Declaration of Self-Sufficiency, you may be required to provide tax returns, bank statements, employment verification, credit reports, evidence of health insurance, and a detailed asset and liability breakdown. Why do people fall for this? Because older cases from 5, 6, 7 years ago, did not require this level of financial disclosure. The goalposts moved, and nobody told you. Here's your exact move. Do not wait for the officer to ask. Prepare a financial portfolio, clean, organized, tabbed, that you bring to every immigration appointment. Include your last 2 years of tax returns, last 3 months of bank statements, proof of employment or income, health insurance card or documentation, a brief personal statement of financial stability. Bring it before they ask. Preparation is not desperation, it is professionalism. And professionalism wins cases. This one is personal. You work hard, you sacrifice, you send money to your mother, your children, your family who is still waiting, still struggling, still counting on you. That money is love. That money is responsibility. That money is who you are. And under the new financial review framework, it can also be a red flag. Here is the truth. Large, frequent international wire transfers, especially those that represent a significant portion of your income, can be used to suggest that you lack financial stability within the United States. It does not mean you have done anything wrong, but it does mean the optics matter. Why do people fall for this? Because remittances are a cultural cornerstone, an obligation, a bond. Nobody tells you that an immigration officer sitting across a desk might see those transfers and draw a conclusion you never intended. Here is your exact move. Continue supporting your family. Do not abandon that, but document everything. Keep records of transfers. Keep records of your income versus transfer ratio. If your transfers are large, and work with an immigration attorney to prepare a written explanation that contextualizes those transfers within your full financial picture. Your love for your family is not a liability, but you need to explain it before someone else misrepresents it. Now, I need you to take a breath, because everything I have told you, every trap, every warning, every fear comes with a counterweight, and that counterweight is the law, your rights, your protections, your power. Here is what you need to know. The inadmissibility on public charge grounds rule, 8 USC section 1182A4. This is the law that governs public charge determinations, and here is what it actually says. No single factor is determinative. Officers must conduct a totality of circumstances review. That means your credit score alone cannot and should not automatically disqualify you. A low credit score must be weighed against your age, your health, your family size, your education, your employment history, your skills, and your overall financial trajectory. A snapshot is not a verdict. Under the Equal Access to Justice Act, if USCIS acts arbitrarily, if they deny your case without properly applying the totality standard, you may have grounds to challenge that decision. You have the right to request a request for evidence response window. You have the right to appeal to the Administrative Appeals Office. You have the right to seek judicial review in federal court. A denial is not always final. Know your next move before you need it. Under the Privacy Act of 1974, USCIS must tell you what information they are collecting, why they are collecting it, and how it will be used. You have the right to request your immigration file through a FOIA request. That file may contain errors. Those errors can be corrected. You have the right to see what they see. The system is complex. It is designed to be. But complexity is not the same as impossibility. And knowing these laws, knowing your rights, means you walk into that office as someone who cannot be easily dismissed. Here is your survival plan. 8 steps. Memorize them. Step 1. Pull your credit report today. Go to annualcreditreport.com right now, not next week. Today, look for errors. Dispute them immediately. A wrongful negative mark on your report can be removed, but only if you catch it. Step 2. Start building your credit immediately. If your score is low or non-existent, open a secured credit card. Use it for small, regular purchases. Pay it off completely every month. In 6 months, that small action creates a visible financial identity that immigration officers can see. Step 3. Never use public benefits without checking first. Before enrolling in any government assistance program, call an accredited immigration representative. Ask one question. Will this program be considered in a public charge determination for someone in my immigration situation? That one question could save your entire case. Step 4. Build your financial portfolio now, not before your appointment. Start today. Create a folder, physical or digital, and fill it with your last 2 years of tax returns, 3 months of bank statements, proof of employment, health insurance documentation, and any assets, savings, property, retirement accounts. Bring this to every immigration-related meeting, every single one. Step 5. Document every international transfer. Keep receipts, keep bank records, write a brief note with each large transfer. Sent to support elderly parent. Monthly obligation. Create the narrative before someone creates it for you. Step 6. Never walk into an interview alone. Hire an attorney or find a Board of Immigration Appeals accredited representative. Many nonprofit organizations offer low-cost or free help. An informed advocate changes the power dynamic in that room. Do not underestimate that. Step 7. If you receive a request for evidence, do not panic. Respond completely. A request for evidence is not a denial. It is a question. Answer it thoroughly, answer it with documentation, answer it within the deadline, always within the deadline. A complete response has turned thousands of near denials into approvals. Step 8. Know what to say and what not to say. If an officer asks about your finances, say this: I am financially self-sufficient. I have employment, savings, and no reliance on public cash assistance. I have documentation to support all of this. Then produce the documentation, short, clear, confident. Never volunteer information you were not asked for. Never guess, never speculate. Speak facts, show proof, stay calm. Let me take you somewhere else now. A different kind of crossing, a different kind of fear. It is 6:15 in the morning. O'Hare International Airport, Chicago, Illinois. He has been traveling for 19 hours. He is tired. He is ready to go home. He hands his green card to the CBP officer. The officer looks at the screen, then looks at him. Sir, please step aside. Secondary inspection. A small room, a different officer, a different tone. The questions begin. How long were you abroad? Who did you visit? Do you have a job here? What is your annual income? Have you received any government assistance? Do you have a bank account in your home country? This is not a criminal investigation, but it can feel like one. And how he responds in the next 20 minutes can determine whether he walks out of that airport free or is placed into removal proceedings. Here is what he does right. He stays calm. He answers factually. He does not volunteer extra information. He does not guess. He does not explain more than what was asked. When asked about income, he gives a clear, specific number. When asked about government assistance, he clearly states which programs he has used, knowing already, because he prepared, that those programs do not count against him. Here is what would have gone wrong if he had panicked, rambled, contradicted himself, or lied, even about something small. That inconsistency becomes a file notation. That notation follows him. Here's what you do if this happens to you. Stay calm, visibly calm. Answer only what is asked. If they ask to search your phone, say clearly, am I required to provide this? I want to make sure I understand my rights. If you are a permanent resident, you generally cannot be denied entry for refusing to provide a phone password, but you may be detained longer. Weigh that reality. If questioning escalates, ask, am I free to go? Am I being detained? May I speak with an attorney? Those 3 questions, in that order, change the dynamic in any inspection room. He walked out because he knew, because he prepared, because he understood that the airport is not just a checkpoint. It is also an immigration moment, and every immigration moment is either prepared for or survived. There is a difference. I want to stop for a moment and speak to you directly, not as a narrator, not as an information source, as someone who understands what this life actually costs. You did not come here because it was easy. You came because the alternative was harder. You left behind language. You left behind familiarity. You left behind people you love in airports, in doorways, in final embraces that neither of you knew would feel so permanent. You came here and you worked. You worked jobs that exhausted you. You worked jobs that were below what you were worth. You worked jobs that never said your name right, but you showed up anyway, every single day. And now you are being asked by a system you are still learning to prove your worth in a language that is not your first, on forms that are not designed for your story, to officers who may not understand what it took for you to sit in that chair. That is not justice, but it is the reality, and because it is the reality, you deserve every weapon the law gives you. You deserve every piece of information that helps you stay, that helps you build, that helps you become what you already are, an irreplaceable part of this country. Your credit score does not define your character. Your financial history does not capture your full story. Your past hardships are not evidence of future burden. You are more than a file. You are more than a determination. You are more than a public charge assessment. And if this system makes you feel small, remember, every major immigrant community in American history has faced a version of this moment, a new law, a new rule, a new reason to doubt, and every single time they stayed, they learned, they built, and they changed what this country looks like. You are part of that story. Do not let fear write the ending. I need to ask you something. Not for me, for your community. Think about someone you know, a cousin who just arrived, a neighbor still figuring out the system, a coworker who has never heard the words public charge, a friend who is about to submit an application without knowing any of this. They are going to walk into that office. They are going to sit in that chair, and they are going to face questions they were never warned about. Send them this video right now before you do anything else. Not because it is content, because it is a warning, because it is protection, because it might be the reason they get to stay. You have that power right now. One share, one forward, one message that says, watch this before your next appointment. That is not a small thing. That is the way our communities have always protected each other, not waiting for the system to help us, but helping each other navigate it. Do that now. Here's what I need you to take with you today. The 2026 credit score and financial review expansion is real. It is already affecting cases, and it will affect more because most immigrants do not know it exists. But now you do. You know the traps. You know the law that protects you. You know the 8 steps. You know what to say in an airport inspection room. You know your rights. Knowledge is not the end of fear, but it is the beginning of power. This channel exists for one reason: to give you information that levels the playing field. Because the system is complicated, but it is not incomprehensible. Because the rules change, but your rights remain. Because officers have authority, but you have law. If you are navigating a green card application, an adjustment of status interview, a public charge determination, or any immigration process in 2026, speak to a licensed immigration attorney or a BIA-accredited representative before you submit anything. Do not rely solely on social media. Do not rely solely on what a friend told you. Use this as a starting point, not as a finishing line, and come back to this channel because the landscape keeps shifting, and I will keep tracking it, clearly, honestly, and without alarm, so that you can make decisions based on truth instead of fear. You built something here. Protect it. You know how now.